Good afternoon, friends. Important judgment from Punjab and Haryana High Court. In the case of Deepak Cells Corporation, if you have wrongly availed GST input tax credit and you're reversing the same before utilization with the interest or penalty leviable, आपने जीएसटी की इनपुट टैक्स क्रेडिट गलत ले ली और आप रिवर्स कर दे रहे हैं बिफोर यूटिलाइजेशन, तो क्या आपके ऊपर इंटरेस्ट और पेनाल्टी लेवीड की जाएगी? इंपॉर्टेंट जजमेंट. In this case, the petitioner was a proprietorship firm. They have transitioned from VAT regime to GST regime. While filing their GST return for the month of August 17, as against 1.40 crore approximately, they have wrongly entered 14.05 crore wrongly. So there was excess credit availed to the tune of 12.65 crore. डालना था 1.40 करोड़ और डाल दिया 14.05 करोड़. wrongly entered. excess credit availed हो गई 12.65 करोड़. Petitioner has immediately sent a mail to the department that he has made the mistake while entering the amount in e-credit ledger while filing the return, but no solution from the department until July 18 return, and then they have reversed this excess credit which was wrongly entered but not utilized. इन्हें रिवर्स कर दिया before utilization. Honorable Punjab and Haryana High Court in this case has held no interest under section 50 subsection 3 of CGST Act. It is important for all of us to know, if you have wrongly availed the credit but not utilized and you're reversing the same before utilization, no interest going to be levied, and that too with retrospective date July 1, 2017. अगर पास्ट में भी आपसे गलती हो गई, आपने क्रेडिट गलत ले लिया और बिफोर यूटिलाइजेशन अगर रिवर्स कर दिया है तो आपके ऊपर ब्याज नहीं लगेगी. दैट टू विथ रिट्रोस्पेक्टिव डेट जुलाई 1, 2017. गलती से अगर आपने ऐसा कोई ब्याज दे दिया है, इंटरेस्ट दे दिया है, यू आर एंटाइटल्ड to claim refund, provided incidence is not passed on. First, for penalty, we know there are two important sections, section 73 and section 74. For non-payment or short payment of taxes or wrongly availed credit, or wrongly availed credit is being utilized. There's the word used or, and erroneous refund. There are 5 subject matter. For issuance of so-called notice under section 73 non-fraud case, under section 74 for fraud case. And here they are saying wrongly availed credit or utilized. Word used or. So there is lot of debate and discussion. Of course, there is relief provided under section 50 subsection 3 of CGST Act. No interest if wrongly availed credit is being reversed before utilization. But what happened for the penalty? Whether department can levy penalty. This is the judgment coming from Punjab and Haryana High Court in the case of Deepak Cells Corporation. Clearly citing and saying, and they have relied some of the judgment which is given in the description box in my detailed newsletter, which you can run through. You can download this detailed newsletter and the citation which is being relied upon. But these judgments are coming from pre-GST regime. And as per these judgment, it is being held. If credit is wrongly availed but not utilized, and you're reversing the same, no penalty going to be levied, no penalty. And this is being relied by Honorable Punjab and Haryana High Court and held in very crystal clear terms and quite obvious, reasonable. If credit wrongly availed and reversed before utilization, no interest, no penalty. That is what it is being held. But in this case, so-called notice was issued, order in original was issued, order in appeal was issued, then petitioner has gone before Honorable Punjab and Haryana High Court. Logical. Just one more interpretation I'm drawing here. If you have wrongly availed the credit and not utilized, then quite obvious you're not using this credit for discharging any payment of tax, right? क्रेडिट गलत ले ली 10 रुपए की और आपने यूटिलाइज नहीं किया तो 10 रुपए एज इट इज वहीं थे, आपने यूटिलाइज कभी नहीं किया. Yani you have not used this fund for discharging your payment of tax. So there is not a question of any non-payment or short payment, which may be a case for levy of interest under section 50 subsection 1 interpretation. So to my mind, still debate is on whether penalty can be levied. Only on premise credit is wrongly availed, my submission would be, if I have availed a wrong credit of 10 rupees and reversed before utilization, is a situation like neutral, as if I have not used that wrongly availed credit for discharging any output tax. Why interest? Why penalty? Of course, you must prove bona fide. You must have substantiation that this was wrongly availed and you have reversed the same before utilization. Very good judgment, detailed newsletter is being given as a link in the description box. Thanks for watching. Stay tuned. Thank you very much.